Welcome back to Law&Crime Daily. We head now to Wisconsin, where the defendant in the Waukesha Christmas parade trial, Darrell Brooks, goes on a nearly hour-long rant as he represents himself against his 6 murder charges for allegedly driving his SUV into parade goers last year. Court on Thursday began early with discussions over Brooks' witness subpoenas and argument over him being called Darrell Brooks. He identifies as a sovereign citizen and has claimed several times he does not recognize his name. The proceedings moved on to witness testimony from a woman who was part of the Dancing Grannies, 4 of whom were killed during the tragedy. Amid her testimony, the jury was excused for another legal discussion. The judge addressed Brooks' repeated requests for stating the grounds for overruling his objections. Then, Brooks went on a 50-minute rant saying he's been treated unfairly and asked that the case be dismissed. He said he didn't have adequate time to prepare ahead of trial, to which the state had an opportunity to respond.
If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude.
Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. Now he's here complaining over and over and over again how unfair this is to him. He is not going into this blind or with one arm tied behind his back. They did all the homework.
Lisa, what's your reaction to Brooks' rant, and have you ever seen these kind of arguments actually be successful?
In my personal experience, no. What happens with self-representation is this. A lot of times you don't have the legal training to even come close to a defense attorney's. You're unable to contain your anger. There's oftentimes false bravado, and it frustrates the judge and the jury. The statistics on somebody actually winning a case is about 10 to 14% when they represent themselves. And a lot of those times, these are attorneys representing themselves. So he doesn't really stand a chance.
Yeah, doesn't know the basics of objections or arguments, and he probably has an attorney helping him, but I think we refer to that as a jailhouse attorney and not the greatest of information. Terry, you've said you would have not allowed Darrell Brooks to represent himself. Why is that?
You know, I have said that from all along. And listen, I absolutely positively respect Judge Darrell's patience. I respect her decision. But the Supreme Court has held that the Sixth Amendment, in addition to guaranteeing the right to counsel, also guarantees the defendant the right to represent himself. And that's why she allowed it. She questioned him repeatedly. And basically, she found that he was knowingly and intelligently waiving his right. But if, in fact, he is disruptive, the court has also said that that right can be curtailed. And there's no question, from the very beginning, he was disruptive, he was delaying, he had all of these tactics. And essentially, if I had been the judge from the beginning, I would have said no. And she would have had the right to do that. She doesn't have to allow him to waste the time of the court. Essentially, what's happening here is Brooks is making a mockery of the system. He's making a mockery of her courtroom, even though I think she's doing a great job at trying to rein him in. She shouldn't have to work so hard. The jury shouldn't have to listen to all of that. And we should essentially be able to proceed forward without having to be delayed time and time again with his antics.
Now, Terry, real quick, just to clarify, when you say no, are you saying no to him not being able to waive his Sixth Amendment right and to represent himself, or no to the continuous outbreaks that he's making in court, or both?
Well, I was just going to say both, Brian. I absolutely would have said no from the very beginning, because while she was doing that questioning, if you remember, he was giving her a hard time and she was barely able to get him to answer. He talked about his name. He kept saying, I don't understand. I'm not agreeing. I have been informed. From that very beginning, I would have said to myself, had I been sitting on that bench, I don't think this is going to go well. I think he's going to be disruptive. I don't necessarily think he is knowingly and intelligently waiving his right to counsel, because he's having all of these discussions about, well, I'm informed. Well, what does that mean? Does that mean you understand? Does that mean you agree? I think she had the basis for denying it, but she was erring on the side of caution. She wanted to give him the opportunity. And she did exactly that. And I can't fault her for that.
Interesting. By that analysis, this might come back on appeal and he might get a public defender, but we'll see how that works out. Thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.